Good afternoon. I can't even say hear ye because we're in Idaho. So I'd love to tell you that I'm happy to be here today. Oh, I can't even say that because I am happy to be here today with the Law Nerds, because today we are anticipating a change of plea hearing for Bryan Kohberger. And with that change of plea hearing, we are expecting to see Bryan Kohberger in court pleading guilty to 4 counts of murder, 1 count of burglary. It is my anticipation that the court will just read the indictment. And once the court reads the indictment, to each charge, it'll be, how do you plea? I don't expect much more to happen in court today, though we do know some of the victims' families object to this plea deal. The court may give them an opportunity to be heard, but that's not going to be a victim impact statement. Those impact statements will take place at the time of sentencing. Sentencing should be set today for a future date in July. So this can be a very quick hearing. It shouldn't take all that much time because, again, there are only those 5 counts on the indictment, and it's changing from the plea entered to a not guilty plea and a waiver of rights, advisement of rights, waiver of appellate rights. So we will go to court and then we will answer questions afterwards. Because court is live streamed and there is not a lot of Zoom room, we will generally go through the court hearing on this one without a lot of stopping. But let's talk about that. I'm going to roll the intro. We're going to go to court. If I didn't say it, it's Wednesday, July 2nd, 2025. Bryan Kohberger is changing his plea to guilty, and that is the hearing we are going to watch together today. So we should go to court. Let's go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, so I put up the court will resume shortly there because that is what they use for their placeholder. So we don't have an OnlyFan, we have a holding page, but this is our holding page so that we can see that court is going to start. So it will show us the court when it's time for them to show us the court. But I wanted to go through real quick the indictment, but I don't necessarily want to pull that up on screen, though I kind of do. So let's go through the indictment real quick because court's going to take a minute to start either way. So let me, where did my tabs got all kerfuffled. It's going to be that kind of a day. Also, for those of you that are like, Emily, what's going on? I am having some knee issues that are causing me all of the business. So I am very slow because walking is a challenge. So if you see me shifting a lot, it's because my knees very much bothering me. But to the wonderful group at the Bone and Joint Institute who took care of me yesterday, thank you. I look forward to seeing you again next week. We're doing better than yesterday. So I appreciate all of you over there at Bone and Joint Institute. Thank you. It was very helpful. So we're just Emily, everything okay? It'll be fine. It'll be fine. Look, sometimes bodies hurt. It will be fine. But I want to pull up that indictment real quick. So we are a number of minutes out. This court will start on time or a little after. It's not going to start early. Court is not scheduled to start for another few minutes. So I am going to go ahead and I have this up on a screen. So we are still going to have it up. The second they change to court, we will also change to court. But I want to pull up this indictment because it's what the court is going to read when the court does the change of plea. It is most likely that this is what we are going to hear because the court will read in each of the charges and ask, how do you plea to charge? And so that's what I anticipate seeing in this. I don't anticipate the court asking him more details. I don't anticipate the court requiring Bryan Kohberger to give more details. None of that's part of the plea deal as we've seen it. I really anticipate, and I'm happy to be, surprised on that, but I really anticipate Bryan Kohberger just changing his plea to guilty and not much more. So on this indictment, we will see the court read in each count. Count 1, and the court will read the language of count 1, that the defendant, Bryan C. Kohberger, on or about November 13th, 2022 in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit a felony crime of murder. How do you now plea? That is what I anticipate. And then that would give the opportunity for a guilty plea then. So we will see that next one, murder in the first degree, and we will hear him the court read each of these in. That the defendant, Bryan C. Kohberger, on or about November 13th, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Maddi Mogen, or Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. And they will read each of those in and change the plea. It does not seem that this plea deal requires any further statements than the change of plea. I do not anticipate that the court will require a factual basis or that more thorough delineation of what happened. I do not expect we will see the court asking more questions. And I do not think we will see Bryan Kohberger saying anything other than the waiver of rights, the yes, I understand, and the change of plea to guilty. That's all I think that we will see today. I am happy to be surprised on that. I would welcome seeing the court ask more questions. I just don't think that's a realistic expectation. And I'm always going to share with you what I think we can expect. And I think what we can expect is the indictment being read and the plea formally being changed on the indictment. That's what I expect. And I expect that the plea deal be discussed. He is getting the 4 consecutive life sentences, no opportunity for parole, so life without parole. He will get 10 years on the burglary. The court will find restitution, and he will waive his appellate rights. He will be advised of those things. I do not expect much more today. The court may give the victim's family an opportunity to be heard about them objecting to the plea deal. But today is not the day for impact statements. Today is not the day. I expect that we will see impact statements. Those are at the time of sentencing. Sentencing will be set for later in the month, is what we've heard. So that sentencing date is not today. It will be set later on. So court should be starting in just a few minutes, and we will see what happens in court today. Again, I'm giving you my realistic expectations for what happens in court today. I would not expect that we will see Bryan Kohberger be required to explain what he did or why. I don't think we will see that. I don't think that that is something that is going to happen with this plea. Sarah said, is it true that he can't appeal this? If he waives his rights to appeal, then yes. If he tried to appeal it, the appellate court would say, no, you can't appeal. You waived your right to appeal. On the outside circumstance, depending on what the case law is in Idaho, there is an off chance that they could withdraw the plea entirely and say, fine, go to trial, but that's very unlikely. Once he's waived the plea deal, then the waiver is done. And once he's not waived the plea deal, waived the appellate rights, it's done. We saw this with Alec Murdaugh, right? Alec Murdaugh waived his appellate rights and then went back and tried to appeal. And the court was like, no, you waived those rights. Stop it. Stop it. This plea deal brings finality to this case. There will be no appeals. It will be done. But in a sense, it won't be for the victims' families, and there will still be an investigation into leaks to the media that we've talked about quite a bit. So we will see that. A number of you have asked, and Stephanie asked, can the feds charge him? He crossed state lines. He can't be charged for murder. No, he can't. This will be the end of that. So he will not be there yet. Thank you, Miguelina. I will take care of that right now because we have multiple things happening. I appreciate that. So we got that. We got it resolved. Thank you. So we have tech stuff going on. There's new stuff rolling out on YouTube today that we have no control over, that we're just ignoring and pretending is not happening because I hope to be able to toggle it off. So for anyone that has questions about things that are happening in the chat, we have no control over it. If we did, we'd turn it off. We can't, and we don't. So I'm going to try to keep it from derailing the chat by just answering questions as we move forward. So a lot of you are asking, will the court require an allocution? I don't think so. It's possible, but I don't think so. Will we see victim impact statements today? No, those are for the time of sentencing, which we have been told will be set later this month. We will have to wait and see what happens in court for that to be set, but he will not be sentenced today. Can they require him say more as part of a plea deal? That doesn't seem to be part of the plea deal. So Alita said, can they, or no, that was the, oh, I lost the chat I was going to grab. Can they charge him separately for each victim? They did in this case. They charged him separately for each victim in this case, and they're going to take a plea deal to each victim in this case, and he will be sentenced to one life sentence for each victim in this case. Let's see. Will he get to wear a suit again? Most likely. Will they release all the details of the case? Unlikely. It's unlikely that we will see everything. It is more likely that we will see, I'm trying to grab some comments as they're going by. It's more likely that we will see the sealed documents and the sealed hearings, if there were any transcripts, those things be unsealed, but it's not likely that we will see the rest of it. So we will just have to wait and see. And I know that there will be a lot of things that are unanswered, which is frustrating. So there will be a lot of things unanswered, and that's frustrating. Bernie said, will the families be in the courtroom? It is my understanding that the families will be in the courtroom and that the defendant's family will be in the courtroom. So that is my understanding. Sandra asked if I would offer this plea. I don't have enough information in this case to let you know, Sandra. I don't have enough information. There's a lot unknown about this case, but until I hear from the surviving roommates, because if the surviving roommates wanted to avoid trial, which it seems to me that they did, that is a very strong reason to consider this plea deal. So I just don't have enough information. This is not an unusual type of plea deal. This is not outside the bounds of prosecutorial and normal prosecutorial discretion. This does not surprise me. This is not shocking to me. This is a fairly normal type of plea deal given the type of case that this is. So it's not outside of the bounds of what is prosecutorial discretion. It does not surprise me, especially when you take all of the considerations, the friends of the victims and the surviving roommates of the victims, them having to testify in a trial that is not only difficult, but incredibly high profile. The uncertainty of jury, the fact that this would go through a guilt phase and then a punishment phase, and then if he was sentenced to death, the fact that you are looking at decades of appeals and then decades more on death row, which most death penalty sentences truly amount to a life without parole sentence either way. So at the end of the day, this saves the civilian witnesses and surviving roommates from testifying. It gives finality where you're not going through 3 months of trial and then decades of appeal. And if for Kohberger, it takes the death penalty off the table. If the death penalty was taken off the table at legal proceedings, I think this would have gone forward to trial. But it seems to me that the defense goal has always been to get the death penalty taken off the table. This accomplishes that. So I understand and have seen much that some of the victims' families are unhappy with this plea deal. I completely understand that. The results at the end of the day are more certain with a plea, and there is more finality with a plea, and death penalty in the way that it is carried out in most states is almost the same type of sentence as a life without parole. So I understand it. And this won't keep popping up with appeals, which also causes quite a bit of frustration for victims' families of why is there another appeal, and why is there another appeal, and why is there another appeal. This closes the chapter, and that might not be satisfactory to some, and I understand that. And that is a difficult thing, and it's frustrating. But the victims' families can give input. They are notified of everything. But if this is what the state is going to do, it does not change that. And that is the reality of how prosecutorial offices work and the differentiation between representing a client and representing the people of the state of insert state here, Idaho. So Lauren said, can the family get answers though? Which I was trying to find real quick, and it disappeared on me. But Lauren in the chat asked, can the family get answers? It really is going to depend on the defendant. there's nothing that can really force the defendant to give answers. And even if the defendant does, just think of the Gabby Petito case and the letter from Brian Laundrie. Did that give answers? It gave his version of answers, but does it change much? And I don't know why this would be much different than that. And a trial wouldn't have given answers other than the evidence that they're going to put on for a trial. So questions of guilt or not guilt is really what's answered at a trial. But the answers that they want, they might never get. And that is a very frustrating thing in criminal cases. A very frustrating thing. And I understand that. So court was supposed to start about 8 minutes ago. We are caught up on live. Court has not started yet. There might be the situation of getting people into the courtroom. This got put onto the docket very quickly, so I'm sure there is some scrambling to get everyone into the courtroom the way that they should be. So, Sweet and Salty, do you think he told all the attorneys exactly what took place? I don't know. It's possible. Yes, it's possible. No. So I can't give you finality because I do not know. Haystack asked if the family can sue Brian's family civilly. No, there is no cause of action for the victim families to sue Brian. We've now defaulted into the Petito case to sue Bryan Kohberger's family. There's been too many Bryans in all of these cases. I'm going to start calling my husband by his middle name. So we will see what happens if they sue Bryan Kohberger civilly. I don't know what they would get from that. I don't think there would be any satisfactory result. JBAZ said, will they unseal all the documents? They should. It might take some time, but they should. It's possible. So, my brain has just completely buffered Artsia Lulu. I pronounce that totally different every single time I pronounce it, so I apologize. Will the defendant's plea, when the defendants plea like this, do the family get the evidence collected by the prosecution? No, they don't. There can be more open discussions when the gag order is lifted, but no, they don't just get all of the evidence. They can have more conversations about it, though. Tyler said, what about the leaked information? There's still going to be an investigation on that, so we will see what the investigation turns up. So we will see. I do not know. We will see the unsealing of the documents at some point, unless there are motions to keep them sealed, which there may be. We will see a motion to lift the non-dissemination order. That won't happen until after sentencing. Sentencing won't be today. So we will just have to wait and see. Today is going to be yes, there is a change of plea, and we know that there's a change of plea. That's what's going to happen today. There's not a lot more that's going to happen today. So I'm going to try to answer some questions that I can ask. There will be some I don't have answered. I saw in the comments, is it bad that they're starting late? I mean, there's no judgment on them starting late. There's a lot of moving pieces to a court hearing like today, so it's not surprising to me that they're not ready to stream yet. They want to make sure that the defendant's family gets into court, that the victims' families all get into court, that any friends and family get into court. It might be arranging seating also so they're not on camera. And then there's going to be the public and the media fighting to get into court. The court had set up an entire lottery system on how to get into court. And that lottery system is not up and running for this hearing. It was meant to be running for trial, and it's not ready yet. So there is going to be scrambling to get people into court as well. So I'm not shocked by any of that, and I'm not surprised by any of that. So we will see. Deborah, we will talk about whether or not Bryan Kohberger can make money from this another day. It seems to me that the case law is after there is a sentence in Idaho that he cannot. So that will that is what I suspect, but I would need to dive more deeply into the case law there to make sure there's no quirks. Virginia said, why delay sentencing when the sentence is determined by plea deal? Because it gives the families time to prepare for impact statements. There are also generally reports that have to be generated from different departments before a sentencing can be carried out. So the practicalities of that may need to be done. There's a lot of paperwork that needs to be done. And there might also be rules regarding what paperwork needs to be done before any formal sentence is done and he's transported. So there is going to be time needed to get everyone into this courtroom today. Marcia Leonard in the chat asked, can the judge reject the plea deal? You're not the only one who's asked. Lots have. It is a difficult question because in this case, that's not going to happen. In cases in general, a judge can reject a plea deal. That's not going to happen in this case. That's not a realistic possibility in this case because this is not a plea deal that is outside the bounds of prosecutorial discretion. It is not out of step with plea deals you would see of this type of case in the state. So this is not the type of plea deal where the judge says, no, I'm not doing that. And it's not like a federal case where the judge gets to pick the sentencing. And there are rules about death penalty sentencing and juries. So all practicality, this is not the kind of case that we would see the judge reject a plea deal in, though judges can do that in different circumstances. So this is just that. Rose Red asked, why would someone plead guilty versus an Alfred plea? In a case like this, and an Alfred plea, by the way, is being able to plead guilty without saying that you are taking responsibility. That's not going to be offered in a case like this. He's not going to be able to say, I'm not responsible, but I'm taking the guilty plea. All right, the court is coming in. Let's make sure that we've got sound up and court is in and ready to go, because I did not hear the court yet. So we should be called to order now. They are in a larger courtroom than we have seen in the past. So this is a different courtroom than they have previously held these hearings in. And we are in court with everyone at the prosecution's table, a very full gallery, most of the defense attorneys at the defense table. And I say most because I don't see Mr. Longston, but this is a much larger courtroom than we have seen in the past.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here
Yes.
as well.
Who are you, counsel?
I'm sorry.
Ms. Allen is here as well.
Ms.
Your
Allen
Honor.
is here as well.
All the way at
Very
the
well,
end.
Thank you. All right, we are here today to entertain a change of plea. Before I start, I want to
Ground rules, I
address
imagine.
some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in
Immediate
immediate
eating.
removal and may result in an inability to attend further court proceedings in this case.
Yep.
I want to point out that there have been calls by some for the public to contact me and
Oh,
my
God.
office in an attempt to influence my decision-making in this case.
I told you all how this would go.
This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are
pissed.
entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly
mad.
inappropriate.
It is.
A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Court should, and I always will make decisions based on where the facts and the law
I told
lead
you that
me,
on Monday.
period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law
Investigated.
enforcement.
Yeah.
I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty.
Yep.
My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime.
Right.
That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon
Yep.
and had no inkling of it beforehand.
And he wouldn't have. The court's not involved in plea deals.
Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And
Which
so
does happen. Please do
that
follow
obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom,
be a lot of security there.
many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and
I
had
bet
to
they
call that
called
short.
everybody
And so I
in.
appreciate very much their professionalism and dedication.
Yeah,
All
I
right.
bet they called everybody in from
That
vacation.
said, let's move
Let's
to the
proceed.
business of today. I understand
This
the
judge is
state
pissed.
and
We'll
the
talk more about it
defense
later.
have reached a plea agreement in this case.
He's going to reiterate the plea agreement and put it on the
For
record
the
what it
record,
is.
I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35.
It's all appellate rights.
This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count, so theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself, will be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well.
All right, and they will continue on to the change of plea. The fixed sentence means no parole. It is 4 consecutive life sentences fixed.
Ms.
Nothing other than life, period.
Taylor, have you had sufficient time to discuss this case
gonna
and
get
all
into the
its
waivers.
ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon.
These will be the
or
waivers?
I guess it's this morning still. I do this to ensure that you so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you.
the first
Now,
time
while
we've
you're
heard him
standing,
speaking
actually,
for
why
it.
don't you take the oath from the clerk?
He's going to be sworn in.
Do you solemnly swear or affirm that the testimony
He's going to have to acknowledge that he is guilty of these crimes and the elements of the crimes, like we read earlier in
And
the
Mr. Kohberger,
indictment?
just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right?
Probably for security as well.
Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your
These are standard
ability
waivers.
to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4,
These
and
are the
5 for
advisements.
first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
These are the waivers. So these are advising him of all potential outcomes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with
continuing waivers?
that I understand you're going to plead guilty today to?
Yes.
Before we get into the change of plea.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
These are standard waivers.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
All right, that's the appellate rights. Y'all, the court has to advise him of all potential outcomes. even
Have
though
you
the
had
plea
enough
deal is
time
for
to
a
decide
fixed
whether or not to
sentence.
plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Those are the final
Has your attorney
waivers?
advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case.
So it's a formal
Should you
written
not
waiver?
plead guilty, did you understand those rights?
Yes.
They include a
And
right to a jury
advisements?
trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
They have
the
the right
rest
to
of the
require the
waiver?
state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you,
So this is continuing on to the rest of the waivers?
to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right.
So they are going through the rest of the waivers and advisements. Before they do the change of plea, there is not going to be a sentencing today. The sentencing will be put over, it's my understanding, till the end of the month, and that's when there will be victim impact statements.
So as to
Not
count one
today.
burglary, the state would have to have proven that on or about November 13,
This is
2022
the
in
language of
Latah
the
County,
indictment.
Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
This is still the waivers. We're not to the change of plea yet. These are standard waivers. When there is a change of plea, depending on the charges, you must be advised of all your
wanna also
constitutional
make,
rights, the potential
for the
maximum
record,
sentences, et cetera.
The defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis,
Oh, there is a factual
that
basis.
purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
I'm interested to
Did you
hear
agree with the
that.
written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road
This is that factual basis
in Moscow,
now.
Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
Those
I
are
would
the
ask the
factual
state
basis
at this
to
time
each
to
element.
provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor.
Okay, the state's going to give a more
Your Honor, the
thorough factual
organization's
basis.
recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University.
Let's see if I can gain him up a
State's
little.
evidence
There
would
we go.
indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants.
This is what the state would
Between-
prove at trial.
July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m., on the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015
Thanks,
white
counsel.
Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November.
I don't know why.
The state's
there's a
evidence includes,
audio feedback.
would include a trial,
That's coming from
video
court.
surveillance of a business on the Moscow-Pullman Highway.
The echo's
just-
not us, it's court.
Just across the state line from Moscow. That would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered
Oh, the court
the
fixed
residence
it.
of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogen and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogen's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single-source male DNA was found on the snap of that
Single
sheath,
source means it's not transferred.
as well as blood from both Kaylee and Madison and other trace evidence. But it's important
It
to
is
know
important that it's single
single-source
source.
male DNA
That's-
was on the snap of that sheath.
That's very important.
The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed-blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that
It would
clear
have
so
been
there's no
charged as
speculation.
such. If it was.
There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on,
We've seen this in the
and
text
saw
messages.
the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later.
This is what the prosecution says they would
Finn's
approve
car
at
is
trial.
seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would have seen that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on
That's on
Walinta, which
video.
is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south
So they have a ping on when
and
his car
heads
entered?
north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone
We've seen
in
that
what
leaked.
appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the
new
defendant's
information.
activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath,
That would be from Amazon.
as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week,
They had a
the
tech
state's
expert for
evidence
that.
will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to
Changed his
change
license
his
plate.
car registration from Pennsylvania to Washington.
And changes plates.
That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case,
And we know this from the probable cause affidavit.
working
Heard about
with
this.
the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body
And
in
we
the
knew
bed.
some of these details from the probable cause affidavit.
Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddi's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court
Water somewhere, I'm
that
sure.
the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings.
Right.
In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. You
Practically
can try to keep
disassembled.
them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do,
Of time
would
to prove all
show
this.
that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddi, Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Colonel. Thank you, Your Honor.
Wow.
Thank you.
The prosecution is, that doesn't surprise me that he's emotional reading the factual basis, but is
All right,
emotional
based
reading
on
the factual
the
basis.
state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count one, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count two, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count three, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count four, the first-degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count five, the first-degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right.
That's the change of plea.
The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case.
On what date?
I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
No
Yes, Your Honor.
reports. Okay.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider.
I mean, the sentencing's a
The
foregone
victims will
conclusion.
be given an opportunity to provide the statements that they wish to at sentencing.
That's the more important
Do we
part.
need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time
to
to
gain
express
him
their
back
feelings
up.
to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right, so because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd.
Oh, wow.
And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the
disruption.
logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give
Wow.
your team enough time, Sandra? 9 in the morning? All right.
All right, that's the sentencing
Any
date.
concerns with that date?
No, Your Honor, thank you.
No, sir.
All right.
They're gonna
Any
be almost
reason
done.
why I should not rescind the non-dissemination order at this time?
Oh,
You're right. I think that given the history of this case, it would be best if
He's
that
gonna have
remained
to
in
wait till
place through
sentencing.
sentencing. So we
Yep.
have
that's what he asked for.
time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place.
Wow.
All right, I will, at this point, the idea to keep it until
Sentencing.
sentencing, which time it would be withdrawn
Good.
in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant.
I don't think bond was
were
ever set
It
either.
would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor, thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be
The
vacated.
court did not do that on the record
and,
yet. That's why he
I'm
asked.
sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
All right. And the court feed is cut. That will disappear shortly. We have the court feed saved elsewhere, so let me go take care of that. But court is done for the day. I'm sure there are a lot of questions, and so we are going to get to those questions because the court ends promptly, and then these feeds get immediately taken down. We have that feed saved with closed captions elsewhere, so if we need to rewind and take a look at anything we can, because this court feed will disappear off of the court's YouTube channel in just a few moments if it's not already gone. So we will answer questions, then we will go back and take a look at any of the parts of the feed that we need to, and we will take a look at any of the feeds that are outside the courthouse. I don't think we will see many statements today. Thank you all, we banged. The non-dissemination e.g. gag order is still in place, so the attorneys and those parties will not be speaking. That doesn't apply as thoroughly to family members, but that will stay in place till after the sentencing. The prosecution asked. The court was willing to revoke it today, which, with how angry the court was at the beginning of the hearing, surprises me that the court was willing to revoke the non-dissemination order today instead of waiting for that to be revoked down the road. So kudos on the court, but the prosecution asked for that to stay in order, so the non-dissemination order will stay in place until after the sentencing. The sentencing will commence on July 23rd at 9 a.m. local time, which is Mountain Time in Boise. So July 23rd, 2025, we will be back here for the sentencing. That will be a difficult day. It will be a day of quite a lot of victim impact statements, and those I expect mostly will be live, though some of those could be letters to the court or letters read by the prosecutors. So with that, the change of plea is done. The defendant gave a brief factual basis, which means he admitted that he committed this crime. These crimes. He admitted to the different elements in the information or the indictment as we read it at the beginning of stream today, and admitted those things. And then the prosecution read in a more thorough statement of facts. That was their proffer to the court of the facts that would be shown at trial. So we had the defendant giving that brief factual basis saying, yes, I committed these crimes. Yes, it was done with the requisite elements of premeditation, deliberation, malice aforethought in the language that we saw in that indictment. Let me pull that up real quick so that we have it while I'm talking about it. So that was the factual basis given by the defendant. That was also written. So at some point that will be on the docket, but it's just going to follow the indictment here. And there were a number of questions about that. So let's go through the indictment real fast before we switch over to looking at anything else or looking at anything going on outside the courthouse. This is the indictment from May after Kohberger was indicted by a grand jury. Remember, May 2023. Remember, we were all waiting for a preliminary hearing in this case to find out more about it. And then it went to grand jury and was indicted, and there was no preliminary hearing. So the facts of this case have remained somewhat unknown because of that. So what we see in the indictment is count one, the burglary. Burglary, again, is not a theft crime necessarily. It is entering to commit a felony. That felony can be lots of different things. Often it is theft-related crimes, but it does not have to be. So the burglary was charged because of the entering into the residence with the intent to commit the murder. So that he didn't go into the house to do something else and then a murder was committed. It is that the purpose of going into the house was to commit a murder. Factually, this can be different in different cases. If somebody goes in to commit a robbery or a burglary or a theft-related crime and then is confronted and then commits a homicide, there are different ways that this can play out, but that is what the burglary is for. The burglary is for entering into the house to commit the murder. That's what he was asked for the factual basis on for count one. He will be sentenced at sentencing to 10 years per the plea agreement. That's the maximum on this crime. The prosecution in this case is asking for the maximum 10 weeks of Massachusetts, and it's just stuck in my brain at this point. And then on to count 2, 3, 4, and 5. We saw the court ask for that factual basis of, did Bryan Kohberger on or about November 13th in Latah County, state of Idaho, willfully, unlawfully, deliberately, and with premeditation and malice aforethought, kill and murder each of the victims, a human being, by stabbing from which they died. So the court went through and asked him to admit to each of those. The court asked the defendant, are you pleading guilty to this crime because you are guilty of this crime? And we heard Bryan Kohberger say yes. And then we saw that very thorough proffer from the state saying, if this case went to trial, then we will see this evidence presented at trial. And the prosecution read that into the record. We can always look at that again. And then I will link below our clean feed of the hearing with closed captioning in case anyone wants to go watch that clean feed. We will link that down below later if anyone wants to go watch that we captured. So that will be a feed that we will list. Let's see. The AP is outside of court, so I'm going to pull that up while we are talking so we can see what's happening. I'm going to turn the volume off on it because it's right now just noise outside the courthouse. I have no idea if anyone will come out and speak to the media. The lawyers definitely won't, but I will put that up just so we have it while we are answering questions so we can keep an eye on that. But people aren't really able to talk in this case, and I'm sure most will choose to talk in their own way, in their own time, perhaps after sentencing. So let's put that up real quick so we have it. I'm just trying to make it a little bit bigger as we mess with layouts here. So nope, that's good enough. And then I will turn the volume off on this, and we will see if anyone speaks to the media. It's unlikely to me that anyone will, but I'm going to leave that up so we can see what's happening. And again, that's just going to be media following people outside of the courthouse. That is not what we are going to listen to, is the background noise of a horde of reporters following folks outside the courthouse. So we will see what happens if it doesn't make me motion sick first, because that's always a real possibility with handheld cameras. I'm going to continue answering your questions. It looks like they do have somewhat of a media array set up. I don't know if anyone will step up to that media array and speak to anyone. It's unlikely that they will, but we can go back to when court ended and to what happened outside of court right when court ended. This is from the Associated Press feed, so we will take a look at that real quick. And again, I don't see, we'll let this roll as people come out of court without volume as we answer questions. So the court today started as I thought they would. We talked about this Monday when I streamed. Monday night when I streamed, we talked about the fact that some interviews we had seen victims' family members asking people to contact the court. I said immediately on Monday, that's a terrible idea, and the court is not going to take that kindly. It is not going to be well taken. It is not, the court is not going to hear from members of the public on this. The court's not going to be persuaded by members on the public of this, and the court is not going to be happy. And the court addressed that immediately today, saying that he was not happy. Now, that's different if the family members reach out, but even then, reaching out directly to the court, it's not appropriate in that context. There is an opportunity for them to be heard in a victim impact statement. There is not an opportunity to be heard before that, and reaching out to the court and going real world is not something that courts are happy with and not something that courts take kindly to. It is something that very much upset the court, and I can understand people feeling that they're doing something, but generally that is not helpful, and it actually, I think, pushes courts more towards not opening courts up to cameras, to the media, etc. Inga, you can disagree all you want. They have the right. It's going to have consequences, though. Victims' families can be heard. The public is not going to be heard by the court. It's not their place. And the public does not have a say in this. They don't. It is a criminal case between the representatives of the people of the state of Idaho, the prosecutors, and between the defendant and his counsel. And the victims' families do have a right to be heard, but there is a time for that. This is not the time for that. And the public has a right to be heard, but they need to be heard through their representatives. Their representatives are the district attorney's office. That is the representatives of the people of the state of Idaho. And the DAs for the state of Idaho aren't going to care what the internet at large says if they are not residents of the state of Idaho. The people who are appropriate to reach out to are the elected officials. And that's why the court gave a civics lesson, or a brief civics lesson, on the different branches of government. The executive branch in this case is the prosecutor's office. They are elected. That is who people can reach out to and let their voices be known. The court is independent from that. The judiciary is separate from that. So the judiciary is not going to take kindly to a bunch of people reaching out to the court. And you heard that today. So whether people agree or disagree, it's the reality of the situation. And I am always here to help with what the reality is, even if that reality is not what people agree with or want to hear, because these things are differentiated. The court branch has a very discrete and specific role. The prosecution has a very discrete and specific role, and the defense has its own discrete and specific role. So when the members of the public are reaching out to the court, it's not going to be well taken by the court because they do not have a role there. When the members of the public in a given jurisdiction are unhappy about something, there are people that they can reach out to. The court is not the people. The court is not the people. The people are the people, and the people are the elected representatives for Latah County. And they will be more willing to hear from the more willing to hear from the community of Latah than from the internet writ large. So that is different. Madeline said, does that mean people could reach out to the prosecution? The prosecution will be the appropriate place for people from Latah County, because Latah County is who elected the prosecutors, and Latah County is who they are beholden to. And there would be generally a public information officer to reach out to there. So the discomfort with, but there should be more room for voice in this, and the reality of these things are separate branches of government, and that's how they're heard, is different. And we talked a lot about that. We are caught back up to where we were. We talked a lot about that on Monday when I streamed. So it looks like they are arranging the media array to see who may, if anyone, come out of the courthouse. So I'm going to leave the media array up here in the corner while we answer questions. There is still a gag order in place, a non-dissemination order. The attorneys can't speak. The attorneys for the victims' families really can't say much. So I don't think we will hear from anyone, but the media is waiting, so we will leave that up. But that is what it is. I will be answering questions. And Lauren, there are victims' rights. They are lined out often by statute, and they have the right to be advised of all of the major steps in the proceeding. They have the right to talk to the prosecution about how they feel about the potential sentencing. They have the right to be advised and kept in the loop. They have the right to speak at sentencing. They have the right to be heard at that time. But the decision to offer a plea deal remains with the prosecution. And that decision, while they will take input from the victim's family do not have to sign off on it. They don't have to agree with it. And victims don't have to agree with plea deals that are offered, though in different circumstances, there are different rights depending on the jurisdiction for victims, not victims' families. But that gets into a very delineated conversation of different types of cases. Sticking to this case, victims' families have the right to be advised of what's happening, but they can't override what's happening. And that is something that we're seeing a lot of tension with and a lot of frustration with. The surviving witnesses, the surviving roommates also have a right to be advised and to be heard. So I understand the tension and frustration here, but the prosecution's not acting outside the bounds of their role as prosecutors in this plea deal. Jennifer asked, can Bryan Kohberger's parents speak? They can. I'm sure that they don't want to, but they can. They released a statement, I think yesterday, asking the media for privacy. So they already indicated they are not inclined to have a conversation. Cray Z said, can the prosecution deny any plea deal? The prosecution doesn't have to offer a plea deal. They're not obligated to extend a plea deal. In some cases, the defendant can choose to ask the judge for a plea deal, and the judge and the defendant can come up with a plea deal and cut the prosecution out of the circumstance. That happens. It is not the usual, but then you are playing to everything as charged, and the judge is sentencing you within the sentencing ranges. In this case, the judge cannot either put the death penalty on the table as a potential consequence or take it away. The only way this plea deal could happen is by the prosecution agreeing to this plea deal to ask for the maximum potential sentence without the death penalty. The prosecution has to take that step to take the death penalty and choose not to seek it. But if that was not the case, then yes, a defendant can say, Your Honor, I want to plea open to you. I'll plea to everything. Fuck these prosecutors. I don't want to hear what they have to say. I'll plea to the court. Sentence me as you will. Yes, defendants can do that, but the prosecutors don't have to offer a plea deal here. So the maximum he's facing, Sarah, is 10 years on the burglary and then a determinative life sentence, which is just a straight life sentence, just life period, life without parole. It is a fixed life sentence, not a 10 to life, 25 to life, 15 to life, none of those. Fixed life sentence, life period. So that is what that is. Sarah asks, is he remanded to custody now? He's been remanded to custody. He remains in custody. He will not be in civilian clothes the next time he comes to court. He will be in a prison jumpsuit. So we heard that today as well. Bex said, just generally, you may think it sucks, but the law is the law. The morality, legality differentiation is hard. And I'm always here to acknowledge where that's hard, but it's also part, I think, of my best service to the law nerds is telling you what is, even when what is maybe not what one would hope that it is. I'm not going to tell you something that's not true just because it might be the more comfortable or more desired outcome. But I do acknowledge where there's difficulty in this. All right. Thank you, Miguelina. We will switch feeds. It looks like there is a little bit of an option from KSL. So let me switch feeds real quick. That does look a little bit better. So let me switch over to that feed. So we're going to switch over to a different feed and see if anyone comes out of the courtroom. They may not, but we will keep it on real time, and I will go back a little bit to see if we missed anything, because this is a much better view. Thank you to our producer, Miguelina. She is the best. So let's take a look. I'm going to take a look and see if we missed anything. We'll just scrub back in time a little bit. Nope. I don't see anybody coming to the podium other than them getting the podium ready. So I will leave that. Let's see. We had somebody sound test, it looks like, but I will leave that. I will leave that up for now and see if anyone comes out to speak. 1 sec. All right. Fair enough. Thank you, Miguelina. So we are switching between a couple different feeds just to see what happens, if anything. Again, it might very well be the case that the camera and microphone array stays there and no one comes out and says anything, and the media's just remaining optimistic. That's a very real possibility here. So I don't anticipate we hear from anyone. It doesn't mean we won't. So we'll leave that up for now. And I'm going to make this just a little bit smaller because, well, if anyone comes out, we will shift to taking a look at who comes out. Let's answer some questions while we are waiting. Hopefully, I've answered some of your questions. The court advised the defendant of quite a lot of information, including what the potential sentences were. But the plea deal here is for a fixed 10-year sentence and 4 consecutive fixed life sentences, which is essentially no parole, no possibility of parole, life, then life, then life, then life. So there is not a possibility that Bryan Kohberger will get out. We heard the court delineate that Bryan Kohberger is waiving his appellate right. He's also waiving his right to argue for a reduced sentence. He is also waiving the right to argue down the road for a change of plea or reduced sentence should the law change. So he is waiving all of his rights with regard to appeals. And that means that when this is done, the case is done. No appeals, no changes of sentence, no changes of sentence if the law changes, no arguing that he should get a reduced sentence at sentencing. And that is really going to be the end of this case, other than the investigation into leaks of the case file to the media. There will be things that will happen, but they're not things that are going to impact Bryan Kohberger's sentence or the legal sides of Bryan Kohberger's conviction here. And he has now today been convicted, which is why the court says he does not have the right to appear in civilian clothes. The presumption of innocence no longer stands because he is now convicted of 4 murders plus the burglary. He is admitted to committing those murders. He has said he is pleading guilty because he is guilty. Not, I'm pleading guilty because I think it's the best thing to do. Not, I'm pleading guilty because I want the death penalty off the table. Not, I'm pleading guilty just to get this done with. The court said, are you pleading guilty because you are guilty? And he said yes. And so that's where we're at with this. A lot of you are asking if the defendant will be required to speak more. No, he will not be required to. He has the ability to, but he will not be required to. So he can make a statement at sentencing. I think he won't. But you never know. He might. So let's go on into some of your questions, and we will continue to see what is there. Let's see. Luann Eva said, I wonder if the TikTok psychic saw this coming. I mean, she's been fighting her civil case like she didn't, so we will see. So let us continue with that. Let's see. I'm going to roll our questions bumper and we're going to get into questions. So let's do one more summary while we're waiting real quick for all of you that have just joined us over here. We were in court today for the change of plea for Bryan Kohberger. In that change of plea, we heard him give waivers to his appellate rights, waivers to ask for a reduced or lenient sentence when this comes to sentencing July 23rd, 2025. That'll start at 9 a.m. local Mountain Time. We will be streaming that. It will be a full day of victim impact statements and statements from those impacted by this case. There is no indication that Bryan Kohberger will give a statement that day, though he will be able to. And the defense will also be able to present a sentencing memorandum to the court, but they can't ask for a reduced sentence because he has agreed to the maximum potential sentence in this case. And on the 5 counts, that would be life, a flat determinative life sentence. So life with no parole. He is pleading to 4 of those consecutive, which means they run after one another, which when it is life, there's not really a possibility of serving multiple life sentences, but they are there. And then 10 years on the burglary, plus the court fees and fines, plus restitution when ordered as ordered. And he has agreed to waive all appellate rights. He cannot appeal on anything. He can't appeal the sentence. He can't ask for reconsideration of the sentence if the law changes down the road, which is what we're seeing in the Menendez case that we've talked about, reconsideration of sentence in that case. So he cannot ask for reconsideration down the road. He has waived that right. The sentencing date, as I said, we'll have an opportunity to hear from those impacted by this case, from the prosecution, from the defense. Today, we heard the court ask in all those waivers, are you pleading guilty because you are guilty? We heard Bryan Kohberger in court say yes. He said yes to the factual basis of the case, which is going through the indictment and going through those elements before the change of plea. We heard the prosecution give a proffer. If this went to trial, this is what we would prove. And a lot of that we had heard vaguer details of in the probable cause affidavit. We have seen some of the things like the car, Bryan Kohberger's car leaving the King Road residence at a high rate of speed after 4 o'clock in the morning. We heard more about that in court today. We heard how many times his cell phone was pinging off the tower in the area of the King Road residence, more than 23 times. We heard about the selfie on the phone after these murders when the phone was turned off, and more details that we had not heard. We also heard from the prosecution the order they think the victims were killed in. We also heard the prosecutor say that they would not try to prove that the defendant went into the home with the intent to kill all 4 of the victims. So there is more information there that we did not hear in court, but we did hear that clarification from the prosecutor. The prosecution gave a proffer statement of what they would prove at trial. The court accepted the proffer statement, accepted the change of plea, and accepted all of the waivers. The only thing left is sentencing. Bryan Kohberger will not appear in court again in a civilian clothes, in a shirt and tie. He will appear in court in a jail jumpsuit. The presumption of innocence, the court reminded him, is gone because he has now pled guilty and been convicted of this crime. So, Chris, if you are watching, the UK is calling me. I do not know why, but I am still streaming. So if you will let them know I am still streaming, because I am still streaming, I appreciate it. That's probably the BBC, but I am still streaming. Thanks. So with all of that, we will see the sentencing come before the court in July. Let's answer some questions now, because I know that you have questions. I will need to do more research about whether or not Bryan Kohberger can talk about this case. The laws in each case are different. So I will need to look more into the case law in Idaho before we talk about that. We'll talk about it in other, we'll talk about it at another time and before send. That was super loud. I cut myself off. No, we will. The BBC I've been on the BBC a couple times. They have had questions about different cases. So I'm going to be talking to them later today about a number of cases. So I'm not surprised that they are calling, but they want to talk about cases. So I have been on a lot of media outlets. I say no to most of them because I rather be here with the law nerds. So when I get asked, 90% of the time I'm like, yeah, I'm going to be streaming. I can't stop streaming and come do 3 minutes on your show. Sorry, I'm going to be streaming. So I am difficult. I am the difficult one to work with when I am asked to do other media outlets because the law nerds come first. And so I put the law nerds first. So no, most of the time I just say no. All right, now we'll get to questions. And I owe you all this because they said it so many times during court and it was not the appropriate time. I owe it to you. I owe it to you. All right, let's get to your questions. Oh my God, that was so loud. And a few of you are like, Emily, difficult? No. Oh yeah, I am the most difficult person to schedule for TV. I'm the most difficult person to schedule because I'm like, no, I'm going to be streaming. And also, I don't have the patience for a lot of legacy media where it's like, okay, we need you to check in with us 20 minutes early and then you have 3 minutes. I'm like, I'm not giving you 30 minutes for 3 minutes of air. No. Also, I can't tell you anything helpful. Like, I can't tell you anything helpful in 3 minutes. So if we've got 3 minutes, then somebody else will give you a soundbite. Like, it's fine. Somebody else will give you a soundbite on that. It's not me. But longer conversations, yes, I am happy to have. It's just difficult, especially with TV media. They are more difficult. So I generally say no. But let's continue on. The question we're going to keep getting, and I'm going to have to just pin them to when I answer them, is will Bryan Kohberger get to speak at sentencing? He has the opportunity. I don't know if he will choose to speak or not, but he has the opportunity. No one said once Bryan Kohberger pleads and receives life without parole, isn't he put in general population? That is not something the court determines. That is something that the location will determine. So it's going to depend on the courts. I am keeping an eye on the live feed outside court. There is still nothing happening there, just so you know. There's nothing happening. We can leave it up, but there's nothing happening. So that is up to the prison system to decide where he will be housed, and that's a safety issue. KFED asked if I will be at CrimeCon this year. No, I will not be at CrimeCon this year. I'm going to be at a lot of DCI events, and then I have some other events that were that I had put on hold for the fall that might change now. So, yeah, that might change now. So Patty said, we all know Emily can't do just 3 minutes. No, I can't. There's no way. There is no way. Law is a conversation. It's not a soundbite. And it needs to be. So a lot of you are asking about soft cheeks. Thank you. Soft cheeks. That's spooly. Thank you. It is a, yeah, Emily spends a lot of time going to drum corps. Yes. For all of you that are newer to my channel, my son marches Cavaliers and it is his first year marching. And so I will be at different drum corps events. Live music is good for the soul. There is nothing quite like it. It really does just rearrange all of the things in your body to make you happy. And I love it. So I will be doing that. So let's see. Kim said, Brian Enton said Bryan Kohberger's parents look sad. Of course they do. There's on a personal note, just what I think about this plea. I understand this plea. I understand why they have chosen a change of plea. Could the prosecution have said, fuck it, we ride, we have enough energy, go to trial, let a jury decide, do this for 4 months? They could have. They have enough evidence to do it. It is, by everything we've seen, and we don't know everything, but by everything we've seen, it is a stronger case. Though we have not seen everything, and I am mindful that we have not seen everything. We saw the defense run a robust defense. They brought up every single issue they could raise. And when all of those doors were closed and the court gave them time and space to have every motion they wanted to run considered. When all of those doors had been shut, that's when the defense went to the prosecution and said, okay, but now can we talk about a deal? That's why this all happened so fast. And I appreciate that the court spent the morning, or at least a little time this morning, saying the reason that the court put this on the docket so quickly is because of the consideration of over 10,000 jury summonses and jury forms being sent out like next week. So this plea deal, the plea needed to be memorialized on the record so they didn't have to move towards trial. This isn't the type of case where if the defendant comes into court and says, no, I'm not going to plea, everyone can just get ready for trial. The vastness of this case and the number of not just security, but the number of jurors needed is not something that can turn around quickly. This case is more like a container ship, less like a jet ski. It needs a whole lot of space to change direction. And so the reason this was put on the record so quickly is because they needed to lock in the defendant's plea. This can't be taken off. There's no takesy-backsies now. It's done. The defendant has pled guilty. He is a convicted murderer. Period. It is done. The sentencing will happen down the road. But the court explained, and I think it was really helpful that the court took the time to explain that the reason this happened so quickly is because the amount of juror summonses that were going to go out were significant. Also, the courthouse was being shut down, and they weren't running any other trials in what is a large and very busy courthouse for the week that they were doing jury selection. That is I don't think I can properly and adequately verbalize how massive shutting down a courthouse this big for a week to do jury selection is. No other trials, no other jurors coming in. So the amount of logistics involved are significant and substantial. And I appreciate that the court apologized and acknowledged how fast this happened and then gave a reason for it. And I appreciate Judge H's transparency on that because it is, I think, needed to tell everyone, look, we have shut down the busiest courthouse in the state for a week to bring in these jurors. And if we're calling off those jurors, we need to call it off now. But in a lot of cases, there will be times when you think you have a plea deal and just day in and day out criminal work, and you get into court and all of a sudden the defendant's like, nah, I don't want to plea, let's go to trial. If you only need a panel of 30 or 40 jurors, it's pretty easy to reassess. And in a lot of courthouses, they have panels of jurors coming in every day. And some jurors go to courtroom 1 and some jurors go to courtroom 5 or whatever the numbering scheme is. And then if you run out of jurors, you go, all right, well, tomorrow bring in a new panel of jurors and all those jurors have been called for jury duty. This is not the normal operating procedure. And shutting down a courthouse this large for a week is going to stack cases up like airplanes trying to land. They are going to be stacked to the horizon trying to get their trials going. And summer is a very busy time for trials. So they are going to be pushing to get the other trials that need to be done between now and really October. Once we get into mid-October, trials start getting delayed and backed up because then you've got November, December, January, and it gets harder to get jurors to come in. It gets harder to get cases to go forward. And then all the attorneys have all kinds of wild scheduling issues. So this is not surprising to me. I appreciate the court. So they need to call off all those jurors, but you can't call off all those jurors until the plea is on the record and done. So this is done. The ghosted woman said, but he can't change his mind now, right? No, it's done. He has been convicted. He has not been sentenced. But he has been convicted. So there is no changing the plea now. It is done. He took the plea this morning, Angie. Yep, you come back. We watched it all together. He took the plea. It is done. He admitted guilt. It's done. The only thing left is the sentencing. And the sentencing will have more time to have everyone heard. So we will go through that a bit more. We've got a lot of questions here. Why was the other plea reversible? The not guilty plea, you can always change your plea. from guilty to not guilty, but he waived his appellate rights, so there's no changing it now. And that's it. KPT, why does he not have to allocute? There's no requirement in the state law that says he does, and there's no requirement from the prosecution that says he does. So he doesn't have to. Just call me Hen. We will cover this topic another day. Today is not the day, because as the law nerds suggested on Monday, I might have to just start yet another channel that is like Emily D. Band and just talk about DCI all summer. I'm teasing. We will cover other cases. What cases are next? I don't know. I haven't even looked at my calendar because I was trying to get in to take care of my knee. Donna Adelson may go to trial in August, so we'll see. No worries, Angie. It is time-stamped if you want to pop back and watch it. It actually took about an hour. It was longer than I anticipated. I appreciate the time they took with it. I appreciate the acknowledgement of we can't just come in. I mean, if you guys remember the Ruby Frankie, Jody Hildebrand. Apparently Ruby and Jody is Judy in my brain. The Ruby Frankie, Jody Hildebrand change of plea was just, do you change your plea? Yes, done. So yes, the plea is done. And it's also a fair fact, Cheryl points out, that he did not plea the first time. He stood silent, and which is something unique to Idaho. I don't know if other jurisdictions do it, but most of the jurisdictions I have been in and seen didn't. So he was allowed to stand silent, which means, it looks like Court TV is taking their microphone back. Court TV is like, nope, our microphone's going with us. So he stood silent, and the court entered that as a not guilty plea. So he technically never entered a plea out of his own mouth in this case. Kimberly C. said, coming in late, will we ever know why? It's unlikely that we will know why. It is unlikely that we will know why. Ellie Baker said, you can stand mute in Michigan. Good to know. Look, the U.S. is so confusing in many regards to many, but the federal law system and the state law system can be so similar but different. Each jurisdiction has its own things. So there's its own quirks. Katie, your lady, said, can he still appeal? No, he cannot. And the Menendez brothers were convicted after trial. He waived his appellate rights. There are no appeals. This is done. Kelly said, how does a civil suit work after a defendant pleads guilty? I don't know if there will be civil suits here. There have not been. I don't know what they would get from a civil suit. The families might choose to pursue that for discovery purposes to get more information. We will see. But we have not seen a civil suit. And how does it work after a guilty plea? Well, he's admitted guilt. So it might just be like, fine, he's civilly liable. But what do you get from that? Because then you don't get discovery. You just get a finding. And he's already been found criminally liable. So I hope the family are able to get more information from the prosecutor's office. So it seems that that relationship is a bit fractured. I hope that they will have time for that. Elliot said, Emily, isn't an allocution usually given after victim impact statements? There are different ways that people colloquially use this phrase. So some are using the phrase allocution to indicate whether he will have to give more information, which I call a factual basis, whether he will have to give more information about these crimes. Some are using allocution as a defendant's right to make a statement. So there are two ways, but Elliot, yes, the way you were using it is the way that I most commonly use it, which means the defendant has a right to make the statement to court, which is why I try to use the more, the less legally phrase of whether or not the defendant will give a factual basis. He said yes to the answers, that's it. And whether or not he will give a statement at sentencing, he has the opportunity to. I don't know if he will. So we will see. Mail Mama said, since he traveled across state lines before and after of this crime, isn't that normally when the federal jurisdiction comes into play? There normally has to be a bit more for the feds to take on a case like this. They did come in and help investigate it. They did not choose to prosecute it. We would want to see more than that. All right, let's continue on. Brawin Grace said, do I understand correctly? He bought the knife before he had a victim in mind. He hadn't moved to Washington yet. He had the knife before he moved to Washington based on what the prosecutor said. Priya, no, there were not more than 4 victims of this case. When I talk about other victim witnesses. I'm talking about the surviving roommates. So when I use those things interchangeably, I am talking about the surviving roommates. And there were 5 counts because of the burglary count. Let's get to some more of our questions. To everyone who gifted memberships, thank you. Welcome to all our new members. The members only lives are there for you. To everyone who's like, I feel a little sad that we won't see a trial in this case. I understand. I am sad for the victim families. A lot of them did not want this result. I am happy for the surviving roommates who will not have to testify in this case. I am very happy for them. I am, sad's not the right word. I wanted to see more information about this case, and I don't know if we will. And I don't know if Bryan Kohberger saying, yes, I am pleading guilty because I'm guilty, will put the questions on this case to rest. I don't know if it will. And though I would like to think that a guilty plea and a sentence to life period, you're never getting out, you can't appeal, it's done, would help put this case to rest. That's not the reality of the situation. There are still going to be docuseries and news series and books. There's still going to be much discussion about this case. So even though it will give a chapter closed on the criminal portion of this case, it's not going to close. It's not going to close the book on this case entirely, because there will still be so much in the media about it, and there will be unknowns. I don't know if those questions will get answered. Kimberly said, for someone who is quote unquote innocent, odd flex to be okay with spending the rest of your life in prison. He pled guilty, saying that he was guilty of this crime. So that's where I'm at with that. Does this mean we can do some food court pleas? Yes. Yes, it does mean we can do some food court. We are not going to do some food court today. There's going to be more things there are more cases we need to cover before we get to food court, but I've been gathering food court stories. We will be doing a food court soon. Renee had asked earlier in the day, any chance of an Alford plea? No, they were not going to allow the defendant to plead guilty on a murder, saying I'm not taking responsibility, but I'm pleading guilty. That wouldn't be allowed. For those of you like, what is an Alford plea? It is a guilty plea without taking responsibility, saying I'm pleading because I want to plead, but I don't take responsibility. That would not be allowed in a case of this severity. And I don't think it should be allowed in violent crimes at all, but that's my own personal opinion. I understand guilty pleas in like DUI collisions where there are civil cases pending and things like that. But sometimes that's a reason to go to trial. If you're dealing with a DUI collision and there are civil cases pending and they want to take a plea, not accepting responsibility, but pleading guilty, then we'll go to trial and find it guilty. I'm not going to deal with it. It looks like there are people walking towards the mic array. So if they stop at the mic array, we're going to turn the volume on and see if anyone is coming up to the microphone. It looks like they are. I don't know what is going to be said, but we will see what happens. Let's go ahead and let's go ahead and timestamp this. I will swoop and we will see what's going to be said. This is live from outside the courthouse. It is just about 12:45 local time.
Good afternoon. I'm Leander James from the law firm of James, Vernon and Weeks in Coeur d'Alene, Idaho. I'm a victims' rights attorney. For the past 2 years, I've had the privilege and the honor to provide pro bono representation in this criminal case for Karen Laramie and Scott Laramie, the loving mother and stepfather of Maddi Mogen. I will be reading.
Chat, yes, he is reading a statement from the family. Yes, there is still a non-dissemination order, but he is allowed to read a statement from the family. He's not giving his own statement. So we will see what he has to say for the Mogen family.
A statement of gratitude today from the Laramies. 962 days ago, we lost our Maddi, our kind, loving, vivacious, and caring daughter full of purpose and promise. We are grateful for the gift of her life, and we have grieved the loss of that life during each of these 962 days. We love you, Maddi, and we miss you. We are grateful for the gift of the young, vivacious, promising lives of Kaylee, Xana, and Ethan, and we deeply, deeply mourn their senseless loss. We remain in solidarity with their families and friends. and we continue to shower them with our prayers and support. We are grateful for their prayers, love, and support that they have given us. They have helped us and sustained us during our darkest times. We are grateful to the prosecutor, Bill Thompson, and his dedicated and caring team, including victim coordinators, Kim and Stacy, who have helped to guide us through the sometimes confusing and disorienting legal process. Thank you for all your dedicated, diligent, and tireless commitment to justice and the successful outcome reached today. We support the plea agreement 100%. While we know there are some who do not support it, we ask that they respect our belief that this is the best outcome possible for the victims, their families, and the state of Idaho. We extend our deep gratitude to the many law enforcement officers and staff who worked tirelessly to obtain the critical evidence that brought justice today, including the Moscow Police Department, the FBI, the Idaho State Patrol, and the Lehigh County Sheriff's Department. We are deeply grateful to Judge Hippler and Judge John Judge before him. We thank you for your diligence, thoughtfulness, and judicial guidance. We appreciate the difficult work you have done to balance the rights of all involved and to uphold the rule of law. You have had our prayers and support throughout this case. We send our love and gratitude to the many family and friends who have supported us, cared for us, and helped us to heal our open emotional wounds. To the good people of North Idaho, who have showered us with kindness and support, we thank you. We also mourn today with you the recent tragic and senseless loss of two brave North Idaho firefighters. We extend our prayers and support to their families. You are not alone. We understand your pain. For all parents who have endured the loss of a child, we know recovery is a long and at times an almost unbearable journey. But you are not alone. And there is hope and there is healing. We thank those in the press who have respected our privacy and the grieving process, and the privacy and grieving process of the families of Kaylee, Xana, and Ethan. To others in the press, we gently encourage you to do the same. We thank the many people across our nation and beyond who have reached out to us, prayed for us, and extended their kindness. You too have helped us on our journey to heal. We now embark on a new path. We turn from tragedy and mourning. We turn from darkness and uncertainty of the legal process to the light of the future. We have closure. We embark on a path of hope and healing. We invite all of those who have mourned with us to join us, and we wish you well. Thank you. I will now share a few words of my own. Over the past 2 years, I've been amazed and humbled by Karen and Scott's strength, endurance, and faith. They have uplifted me and so many. They founded a nonprofit to help others in the name of Maddi. They have been a beacon of hope amidst a dark and tragic time. To those young and bright attorneys out there looking for purpose and meaning in your profession, I invite you to join the effort of crime victim attorneys to bring victims justice with compassion, empathy, humility, and understanding. This case is not the end of violence. This case is not the end of lawlessness. We need your help to bring hope and healing to the innocent caught in the crossfire of life. Thank you all.
Sir, could you just say your name one more time, sir?
Leander James, Leander, last name is James. Thank you.
Okay, and that was a statement from Madison Mogen's family through their attorney, who indicated that he is a victim's rights attorney working pro bono with this family, and gave a statement of closure, encouragement, support, and gratitude. When we talked about this earlier, that some of the families were upset, it bears, I think, repeating now that some of the families are not. some of the families agree with this plea deal. And I understand that too. You have a quadruple homicide. Each family has to walk a very difficult, very isolating, and very unique path with grief in this. And so it does not surprise me that we see a statement. Well, actually, it surprises me a little bit that we see a statement from Maddi Mogen's family attorney, given that there is a non-dissemination order. But honestly, what is the court going to do at this point? You know, what's the court going to say? They didn't talk about anything that was in the evidence. They gave a statement to the media. Other families have given statements to the media. I don't think there's going to be much more. For those of you asking, will anyone else be speaking? I don't know. There are people adjusting the microphones. It's possible. We are in real time, so we will wait and see. But the media also doesn't know. They're waiting to see who walks out of the courthouse to see if somebody else walks up to the podium. But each family's going to have their own feelings. Each family's going to have their own path with grief. And each family is going to handle that in their own way. So seeing the statement of support for the plea deal surprises me only in that it was a statement given, not written to the media, but given at the microphone. That's the only part that really surprises me. I appreciate that the family had the ability to voice how they said, that the media was respectful enough and not just shouting questions at them. And hopefully they can start to feel like a chapter is closed in this and they can move forward. And they said that in their statement. And I think that that is appropriate. I also think it has to be hard for the parents of the victim roommates and the parents of the surviving roommates to reconcile all of the different types of grief and all of the different facets of grief, because I'm sure the parents of the surviving roommates are really, really happy that their kids don't have to go through this trial and live with the fallout of testifying in a trial like this, in addition to what they've already been through. And I understand the fights and frustrations between the parents. Not fights isn't the right word, but the tension that might be there, because everyone's got their own opinion and every family has the right to their own feelings on this. But ultimately, it's why the prosecutor's office is the final say. Prosecutors represent the people of the state, and it is their job to do justice in any given case. I am most critical of prosecutors' offices when it feels like what they're doing is not that. But in this case, is the difference between a death penalty sentence and a life without parole sentence so, in reality, so different that putting the state, the roommates, and the victims' families through a trial, a penalty phase, and decades of appeals, is that the right thing to do with a case when a defendant is willing to say, I'm the one that did this, take responsibility for doing it, and be sentenced to life in prison? That's a really difficult call for prosecutors, because I'm sure there are defense attorneys saying, why would he Kohberger take this plea? What benefit is it from Kohberger? The only benefit for Kohberger there is that the death penalty is 100% off the table. However, if laws change in the next 10 years, and laws across the country have continued to change on the death penalty, if the death penalty is revoked in Idaho, if the legislature changes it, then if that happens in the next 20 or 30 years, then that wouldn't even be on the table for him then, because it would take at least that long to get through appeals. So is it surprising maybe to some, looking at this from a defense perspective, that he would even bother taking the deal and wanting to take the deal without going to trial? At trial, you have the opportunity that the jury might not agree with the death penalty, might sentence you to life without parole. At trial, you have the opportunity that maybe something happens and there's a mistrial. Maybe something wild happens with the jury and there is grounds for appeal. There are a lot more opportunities, and you, as a defendant, leave the door open that with changing laws, your sentence may be changed. This closes all those doors. And he waived the right, if the laws change, that he gets to change his sentence. So it's a lot to decide. But I think some looking at this from the defense perspective, I think some looking at this would wonder why he, defendant, would want this deal. Where is the benefit for him? Other than there's finality for him too. So there's a lot of, it's not always easy to look at both sides of a case, but I can see from a defense side where they're saying there's a lot of opportunities for you, even if you are convicted, even if you are sentenced, there's a lot of opportunities to kick that out. There's a lot of opportunities for the law to change, society to change, to be resentenced, for appeals. There's a lot of that. And from the prosecutor's side, why would you offer a no death penalty case? Those things are a little easier to conceive of. It looks like others are taking their microphones, which means there's probably nobody left within the courthouse. So it looks like others are taking their microphones down. I'm sure it is hot AF out in Boise today, and they're probably happy to take their microphones and go home. So with all of it, I can understand both sides why people would want one thing or another to happen, but I can also understand the reality of a prosecution like this, why the prosecution would make the choice that they made, even if some of the victim families don't agree with them. So that is ultimately their choice. And I think we hear some of the other side on that with the statement from Madison Mogen's family. So with that, we will get back into questions. It looks like we are done. I'm going to leave this feed up in the background for me, just so I can see it. In case anyone else does come out. I doubt that they will. I don't know if, well, on this feed, no one else gave a statement out front of the courthouse. This was the only one that we saw. If there are other feeds, Miguelina will find it and we will go take a look. But we watched, for those of you just popping in, the family statement from Madison Mogen, and for replay crew, all of that's timestamped down below. Okay. Erica said, knee ablation this week. I feel your pain. I get it. I'm definitely not doing that this week. So thankfully, that's good. It's actually Ashley said, EDB, I was in Nashville first time this weekend. Man, the drinks go down too easily. Everything hurts. Love Tennessee. And it was warm, and you got some of our weather as well. So it's a lot. So let's see. Let's get to some of your questions. It's good to see everyone. All of our new members, all of our gifted memberships. Thank you. Mary Catherine, I answered this much earlier in stream, and that'll be timestamped. And the court was very clear about their role in this. And I think the judge did a good job of expectation setting at the beginning of the hearing. So Piney Woods said this case is tremendously tragic. It is an incredibly sad case, and there will be things that are not answered. And that is a difficult thing to accept. We as humans, switch feeds. Thank you, Miguelina. We as humans don't love uncertainty, and we don't love not having answers. There are things we will not know about this case. And that's a hard reality. So LR in the chat said, EDB, not a question, but I looked up aphantasia because I couldn't believe it's a thing and learned that one of my favorite professors from college, a mega brilliant woman whom I love, has it. So interesting. I made a comment on an Instagram reel where people were talking about aphantasia, which is the blind mind's eye, the mind's eye that does not see in images. And we have talked on stream other times about the aphantasia scale, that where you see or don't see something in your mind's eye. And it is hard, I think, for people that have a vivid mind's eye to understand that without a mind's eye, it's just there's nothing there. And people are like, what do you mean there's just nothing there? There's just nothing there. And so this was something I discovered when we were going through the Paltrow case. Because again, when people were like, oh, just visualize it, I always thought it was like just a hyperbole statement. I didn't really understand because I never asked my husband, like, how do you think about something? And so when I started to, he's like, no, I can see 3D images where I can like move them around. Like I can just imagine it. And I'm like, and like see it. He's like, yeah, you can imagine it and just see it. And then visualize was always like I don't know, you just visualize it. Okay. What does that even mean? I can't visualize anything. So my water polo coach always talking about like, see the plays in your mind. I'm like, what? What do you mean? No. And then talking to other friends who are like, no, when I'm remembering like case law, I can actually see the page on the book and see the title and almost reread it because I can see it in my mind, which also when my friends and I would be like, talk about books or what have you, and they'd be like, I don't like the casting of whatever character. That's not how they look to me. I'm like, I mean, they have brown hair. It says they have brown hair. I mean, that's fine. Me, it's more vibes. It's like that actor doesn't vibe with my vibe of the character, but that's not how they look to me because there's no look for me in books. Like I don't have a look. So I'm like, I'm never really that displeased with casting unless the vibes are off because I don't know. I don't know what they look like. Anyway, wild. Wild. So Z said EDB, does having aphantasia make it hard to create what? Like I can't draw things from memory. I would need, if I was to try to draw, I would need a reference of something. I also, when we work on like designs for the merch shop and it's like, well, it could be here or here. I'm like, I need you to show it to me. Like, can you make a picture? Because I can't just imagine what that would look like bigger or smaller or in a different font. I need you to just show me. Can you just show me? And then if my husband's talking about something in the yard, I'm like, can you just sketch it out and show me? Because I don't know what you mean. And he's like, well, this would be here and this would be there. I'm like, I hear the words you're saying, but that's not, I don't know what that looks like. Can you just draw it for me? Which is also why I need visual and auditory maps. I do much better when directions are spoken to me. But it's like, oh, I'm terrible at like, I don't know, size matching things. It's like, will this fit in there? I don't know. I don't know if this will all fit in that suitcase. I got to just try it. I don't know. He's like, but you look at it and you can tell if it fits or not. I can't. I can't tell. So it makes things more difficult, but it also explains why at all the like the Tetris games, I am terrible at them because I can't be like, oh, will this fit here? Will this fit there? I can't see it in the beginning. I don't know. We just have to try it. So I don't know. So yes, I'm always here to talk about all the different levels of neurospiciness. J Spot said, Emily, my wife loves your channel. Been listening for years after Karen Reed's trial. Now I am a fan. Well, welcome, Jay. We have more trials to come. We'll talk about those next week. Ali Katzia said, do you think the families will consider legal action if they haven't already? I don't know what is to be gained by that. So I don't know. If they do, we will see it. I just don't know what is to be gained by that. Lady Jane, I think a lot of people feel that Kohberger should be required to say what happens. That's not a requirement of the plea deal. It's not a legal requirement. And so what happened in court is about the end of what he will be required to do. He was required to say that he's pleading guilty because he's guilty. He was required to say, I went into the house he went through the elements, went into the house on November 13th to willfully, unlawfully, deliberately, and with premeditation and malice aforethought to kill each of the victims. He had to say yes to those things. And so that's about all we will see. Stella said, after today, will the surviving roommates be able to tell their story? No. Not after today. They have to wait till after sentencing if they choose. They may or may not choose, but if they choose, so they will have that right after sentencing. They will still be under the non-dissemination order because they are witnesses. Chris said, EDB, after dealing, can he claim ineffective counsel? No, he cannot. He has no appellate rights. And he was asked if he waived all of that and was asked about the sufficiency of his counsel, etc. And so they already took care of that. So, Rena said, what are your personal thoughts on no trial? I think I already gave those pretty thoroughly. I am happy for the witnesses that won't have to testify. I am sad for the families that feel that this does not meet their wishes and that this is not justice for them. I understand why the district attorneys would be willing to do this. I also worry that without this case coming more thoroughly to light, that there will be remaining questions, but sometimes the trial doesn't answer those questions anyway. And I just wonder if the lack, like the void of answers, will make the speculation worse. I don't know. But going to trial or not going to trial doesn't bring anyone who was murdered back for their families. Going to trial or not going to trial doesn't give them the answers that I think they want and they might never have, which is a frustrating reality. Going to trial can make things worse for the surviving roommates because trial is not easy. Being a witness is not easy. So I get it. There was more about this case I would have liked to have seen, but we're not going to. But I'm also, I don't know, I'm used to being okay with knowing what I don't know, even when frustrated, because I don't know, it is part of the law that there are things we just won't know. And I have to accept he said he's guilty. He said he's pleading because he's guilty. And that is the end of that. The prosecution was never trying to prove motive. And so we will never know about motive. And we will never hear about that because they were never going to prove motive at trial anyway. So we will see. Let's see. I've gotten a couple other questions about, do I think this was his first offense? I'm not going to speculate on that. I don't have any information one way or the other. So I'm not going to speculate on things that are not within the purview of the court, which is why I stick to court. Bree said, I'm curious about this book on Amazon. I gave my thoughts on it on the episode where I was talking about it. I don't love it. CHRR Chur said, going to my first DCI in Seattle tonight. Have the most fun. I think Boston Crusaders are on the West Coast. So have a great time. If you've never been to DCI before, it will be loud. It will be amazing. Just enjoy the vibes. Everything will be great. It will be so much fun. And hopefully it won't be too hot. So Brooklyn Mom said, same. I learned about it about 8 years ago. I mean, it's always weird learning how our brains work. Amanda Scott asked, will the families and victims get a chance to speak at sentencing? Yes, they will get a chance to speak at sentencing. Those who want to, those who don't want to speak at sentencing will have the opportunity to put forward a written statement to the court, etc. So let's see. I'm going to try to answer more question on that. What are your thoughts on Ann Taylor today after her hesitation on time for discovery? I don't know if that's a part of their waivers all the time or if the court was asking her that specifically because of this case, but I'm not surprised that she paused for a moment because the court wrote that scathing order just last Thursday, not even a week ago, that we went over on Monday, the scathing order about the motion for continuance. So my thoughts are it was a moment because she was required to answer to the court if she had had enough time to prepare this case after the court excoriated the defense a little bit in their motion or in their order last week. So I think that pause was a moment between Ann Taylor and the judge because of how frustrated he was. Kathleen asked, how does he pay $50,000 for restitution? He's not been ordered for restitution. And we don't know if he will be ordered to pay restitution. We will see. But that was potential court fines, which are separate from restitution. We will see what, if any, restitution is ordered. And then we will see what, if any, court fines are ordered when we get to that at sentencing. Purple Wolf, it is YouTube rolled out a new thing in chat. I can't turn it off yet. I've asked. I cannot. I have no control. But Nightbot has instructions for how you can turn it off on your end. I cannot turn it off for the channel, unfortunately. So I don't have the ability to turn that off. I wish I did. Vinter asked, what happened previously that made the plea come now? I talked about that more on Monday. I think the recent rulings, the defense started the case with all of the avenues, all the legal avenues are open. So if you think about having either a lot of open doors or a lot of different routes to a place, all the doors were open at the beginning of the case. And as the case goes forward, the doors start to be shut. And so as the doors start to get shut, the defense ends up with very few doors to walk through or very few avenues. And the avenues that they were left with at this point were try to get a plea or try to go to trial. So all of those rulings were really finalized last week, Thursday, on the 26th. So as all those rulings were finalized, there are less avenues left. And one avenue that they had left to them was to go and ask for a plea deal. So that is what it is. Let's see. Is there such a thing as a death penalty without appeal? No, Martha, there is not. It comes with quite a lot of appeals. The court said up to $5,000 per victim of court fees. That's on the case. That's in addition to restitution. So that is in addition to restitution. So Dawn said, going to DCI in Erie, my son's friend is marching. Dawn, what corps is your son's friend marching, and have the best time? I know there's one in Allentown. Are we talking Erie, Pennsylvania? We might be talking a different Erie, but have the best time. Jamie asked, how will he pay restitution if no income? There is often the opportunity to earn income in custody for work in custody, so we will see. Let's see. I'm going to get to other questions I can answer. We will talk more about Kohberger and rights and books and movies. There's some case law I want to look at before we get to it and give you an answer. So today we will talk about that before sentencing. Elizabeth Ann said, I know you joke about an EDB banned channel, but this is more appropriate for elsewhere, but sent you a message on Instagram regarding the people who ask what DCI is. No worries. I am very, and I love that people ask, because this is the marching band world is one of those things where you're like, wait, that happens? Yes. So yes. Let's see. So it, you never know. There might be room for that. Fatma asked, what are the fines for? Every jurisdiction has different court fees and fines that are part of a potential sentencing in a case, and different jurisdictions use those differently. But there are court fees that go towards costs of prosecution, and then there are court fines that go with each case. So sometimes people will be fined and not sentenced. So court fees and court fines are separate. Those go to the court. Sometimes those go to different types of funds. And then restitution goes specifically to the person who needs restitution. So the victim or victim's family of a crime. Noma asked, can the families depose Bryan Kohberger in a civil suit and get some answers? It would be very difficult because he's already pled guilty. So there's not much left to be determined in a civil suit. So the civil suit could be resolved on a factual basis before it even went to depositions. So it's not as easy as just suing to get some answers, unfortunately. Cast the Sass said, EDB, can you explain what single source DNA is? Cast the Sass, that's a great question, because I mentioned very quickly that was something that was important for the prosecution to point out. There had been much discussion in this case about DNA, about the source of DNA and where DNA is coming from. And when there is transfer DNA most often has the DNA from the person who transferred it. So if you see an example of somebody being like, oh, if I touch, I think in this case they use the podium. Like if all the lawyers in the day touch the podium, one lawyer can touch the podium and pick up possibly the DNA of another lawyer on their hands and then go touch something else. And that ends up with DNA getting transferred by touch through different things. But that DNA would then show both the person who picked it up and what was picked up. It would show multiple sources. So single source indicates that it got there from one person touching it, and it leans more strongly against someone else transferring that DNA there. So that is why they made such a big deal of single source of DNA. It wasn't transferred there by someone else. It wasn't put there by someone else. It wasn't someone else who touched it and what have you. So that is why the prosecution made a big deal about single source DNA. So let's see. We're going to get to just a few more questions and then we've had a very fulsome day. It is a holiday weekend. Sandy Bug said, EDB, could the prosecution have mandated he disclose where he left the murder weapon as a part of the deal? Those are very hard to enforce. Also, I don't know if it matters if he's pleading guilty, because I think the prosecution probably has a supposition of where that went. And I think they probably have a supposition of where that went, seeing that he was trying to replace it, which when there are lots of waterways, there's probably a supposition. I swear I'm still cool, said Costco being sued by Lululemon. I saw that. I put it on my docket to get to some civil cases that aren't quite as heavy. Aaron McCall said, I'd like to propose a motion that we get a lol bot. It would probably just be law bot, but like Ryan Hall's y'all bot. I appreciate the suggestion. I think it is great. I know that Ryan Hall built the y'all bot himself. I don't know if I got into wanting to program my own bot, if that would become a hyper focus and you wouldn't see me for like 2 months. So I don't want to start a project that I can't complete and not stream, but it is on the list. Right now we have the pop-ups on the case briefs, and that's where we're going to leave that, but it is on the list of what we can do with the definitions and putting definitions up on the screen. We are working on it, but going to program my own bot would probably take me down a rabbit hole of messing with technology for weeks and weeks and weeks. And then I would never stream. I'd be like, wait, I can't stream. I got to fix the bot. Like it has the ability to potentially derail me from keeping abreast of what's going on in all of the legal things, because we need to get into other cases in other areas. So we need to do that first. And then there is a secret project that I have been working on that I really want to get done first. That's taking some time. So I have like a list of things, and I don't want to run down a rabbit hole that I can't complete, because then I would just lose my mind. Claudio said, is this the first case using genetic genealogy outside a cold case? No, it's not. Genetic genealogy is used somewhat regularly now, but it might be the first high profile case, but it's not the first case where genetic genealogy has been used. So it is not, but it is, well, there's not much more to say about that. It is not. I'm surprised he didn't give location of the knife or any other missing evidence. He's not going to be asked to. He's asked to say that he's guilty. He said that. I imagine it is, where's the money? Well, it's recirculating. It's just, where is it? If it went into a waterway, which is possible in this case, then there's not much more to do with that. So let's get to a few more. Martega asked, why was his dad's or family DNA on file? It wasn't on file. Going back through how the investigative genetic genealogy worked in this case, there was a trash pull. There was a relative of some sort on file in one of the multitude of civilian DNA databases that seemed to narrow that down. And then they did a trash pull. And then from the trash pull, they did a profile from what was pulled out of the trash, and then the profile from the knife sheath. And that profile came back to be paternal relation to the knife sheath. And then they used the trash pull to get the search warrants. So it went from a larger familial, somebody in the database of the proprietary and public databases. They used that to narrow it down, then did the trash pull. The trash pull was done when the trash was discarded and not within the curtilage of a home or under control. So they grabbed the trash, pulled DNA from the trash, then compared it to the knife sheath, then got the search warrants to arrest Kohberger, then got his DNA subsequent to arrest, then used it to match. So it was multiple steps first, but his dad's DNA was not on file. there was somebody in the familial line that was on file in something like a Ancestry, 23andMe, or one of the other ones, because they used those first. All right, let's see. I'm going to try to get to some more questions. I see all of your statements, but I'm going to try to get to the questions. Carrie Reed asked, what do you think about the way Idaho handles cameras in court? Personally, I love the setup. I do too. I think it's great. I wish other courts that had concerns about cameras in the courtroom would just do that. When we see Utah's very concerned, and with the concerns in Utah, I think that using their cameras in court like Idaho does might help reduce some of those concerns. When the court's in control of the cameras, it seems to alleviate some of that tension. And in Utah, we really have a concern from Judge M about cameras in the courtroom. I wish that they would do this too. And most courts are set up for Zoom court. We've seen Utah, well, we haven't on stream because it's not streamed, but I've attended Zoom court in the Corey Richens case in Utah. They are set up for Zoom court. So there are cameras there. I wish that other courts would do it. Does that put more work on court staff? Potentially, because it causes other types of potential issues. But if the tension is between access to the courts and not really wanting someone else in control of the camera, I think it's a really good middle ground. I like it a lot. I wish courts would just do that. If they're worried about it, just do this. Just do this. Just stream it yourself. I like it. Just like a C-SPAN feed. I think it's great. So I'm happy with it. And I wish that courts that were concerned about cameras in the courtroom would just do that. So those are my thoughts. For those of you asking what case is Utah again, Corey Richens. It's a whole different thing. Let's see. Lovely asked, when is trash actually considered trash versus not? Oh, Lovely, there's a whole bunch of case law on when it's considered discarded or not discarded. That can vary by jurisdiction. So each jurisdiction has a different definition of when something is discarded and how close to a home or a residence it is, when it's within the curtilage, not within the curtilage. This is a whole like first year law school situation, but generally once it is put out to the curb, though there were some arguments about that in this case, but once it is put out to the curb to be collected, it is generally considered discarded, though there can be some variations state by state. If something is put into like a community dumpster, it's considered discarded. If it is next to the house, it's not always considered discarded, so it can depend. In this case, they waited until the trash company had picked up the trash can and then took it from the trash company. So the trash company had taken possession of it, then it's clearly considered discarded. But yes, things that you put in the trash can be recovered. It's why everyone should have a shredder, first of all, because if you're throwing out physical copies of bank records or personal records or medical records, all those things should be shredded. So within the curtilage, not the cartilage, the curtilage of the home. Oh gosh, I would have to get to law school definitions of what is considered the property of a home, and within the property of a home, and these often comes up in the Fourth Amendment context of searches and seizures, and is looking through someone's window and seeing that they have like a lot of these cases where marijuana grows. So assume it's illegal in these examples. But if law enforcement came up and walked up to your window and looked into your window and saw a bunch of apparent marijuana plants, could they then go, we need to get a warrant, we saw it from outside? Or are they entering too close into the house where you have a reasonable expectation of privacy? When is the reasonable expectation of privacy? How far from a home does it expand? What if law enforcement is like, I think you got something in that yard. What do you got in that yard? And throws up a drone and flies over your backyard. Then can they get a search warrant for something you might have in the backyard? Where are the boundaries of that? How far above the house does it have to be? How far above a house does a curtilage extend? Fourth Amendment search and seizure. What if they use like a heat gun where you can see that things are warmer or cooler and say, oh, they must have a bunch of like grow lights in that house because the house is hotter and puts off more heat than other houses in the area are, et cetera, et cetera, et cetera. So there's a lot of case law on that. It is something that is fought over in search and seizure Fourth Amendment law quite a lot. Where are the boundaries of your reasonable expectation of privacy? So hopefully that helps. Because there's quite a lot of, there's quite a lot more there. Katie's like, I'm having traumatic flashbacks to criminal procedure. Yes, there's quite a lot more there, but know that there's an entire area of case law that explores things like how far under a house, how far over a house, how far around a house. What about when it is a multi-dwelling living? Is that different if it's an apartment building? Is it different if it's a townhouse? Is it different if it's an Airbnb? Like, then who's got a reasonable expectation of privacy? Is it different if it's a hotel room? Then what reasonable expectation of privacy do you have? And then. So we'll get there. So we will see. Lorraine E.T. said, funny you mentioned that, Emily. I had a friend who kept getting visits from the police and the power company because they thought he was running a grow up. He was running a data center server farm. It's like, no, I'm mining Bitcoin, not growing weed. But there's times when they think you're using more power than maybe you should. When is the what is being done? But yes, 100%. Okay. I'm going to answer some more questions and then we will go from there. And I think this is fair too. Cindy said, I have grow lights for my veggies and strawberries in my apartment. So of course I have funny lights in my windows. I had to call the cop on a guy outside my windows, right? Because they were probably wondering if they needed to target your house to see if you had any of that sticky icky in there to see if they wanted to rob you. So yeah, I don't understand. I don't doubt that. And you have to be like, no, I'm growing strawberries. Leave me alone. I know. Everyone is like, 1L Civ Pro, stop it. I know, I'm sorry. We'll be done. But yes, they will look to see if you are using more energy than your neighbors, amongst other things. So yes, people are looking for grow operations for sure. Also, I'm from California, so you're not going to find me being all put out over weed. You guys know how I feel about it. It's dumb. So, but the problem with grow operations that we had was the subsequent crimes of people breaking and entering to try to grab the plants and steal the plants and all the rest of it. So that is a very basic overview of the Fourth Amendment. Let's see. And I see all of the feeds in this case are done. I'm going to take one quick look and make sure that we didn't miss anything that I would want us to look at. So let me take a look real fast, because other than that, I think we are just about done. Cindy said the cops did come in. I mean, they're going to want to look, right? But it's like, no, please don't. I'm growing food, which I think should be totally normalized. But I understand that. I'm just going to take a look and see if there's any more readily apparent conferences that I see on this case. I'm not seeing any at first look. I'm seeing a lot of my stuff. So let's see. Yeah, I don't see any other statements. If we see any, I will cover them in the coming week. What I plan on doing, and I'm going to answer a few more questions before we move on, but what I plan on doing for the podcast is to record tomorrow. I'll talk about the Diddy verdicts tomorrow in the podcast. That'll come out on Monday. And then we will look at what we're doing next week. I will, of course, cover the sentencing in this case. Just bring your Kleenex. If that's going to be a hard day, it's going to be a hard day. It is going to be all of the emotions. It is going to be tremendously sad. It is going to be a hard day. So for all of you that might come in and be like, Emily, I'm sorry, I can't. You don't need to apologize to me. Take care of you. It's going to be a difficult day, but we will cover the sentencing and we will cover it live the way that we did today. And we will, I might try to do it on just a touch of a delay from our refeed so that we can add closed captioning to it. So I'm going to think about that. It'll be just like a 35, 40 second delay so we can have closed captioning on it. I might do that so that we have it today. I wanted to make sure that we were in real time, but I might do that for sentencing. So I will let you know. That will be a difficult day. I will be covering kind of updates on other cases between now and then. I will keep you posted in the app about what we're covering and when. We will do a food court day. For those of you that are like, what are food court? Lawsuits over food. Food court is lawsuits over food. Lawsuits going on with food. We've got some Taco Bell lawsuits we haven't checked up on. Most of them are false advertising, but some of them might be taxation. Some of them might be other things. But food court is covering food only, food issues, drinks, taxes, what have you. We will do another members only stream soon. And I will look at an updated docket. I haven't even had a chance since this happened on Monday. I haven't even had a chance to think about what's next. Honestly, part of that is because of my knee. Part of it is because this happened so incredibly fast, just so incredibly fast. So we will be doing that in the weeks to come. Again, there's not a lot of time between now and sentencing in this case. We have updates in other cases that I want to get to next week. And then if Donna Adelson goes to trial in August, which is what it looks like now, then that will probably be the next thing. But I have not had a minute. A lot of you were like, today was really emotional. 100%. 100% it was. But I will take a look at what's on our docket and what's coming up and go from there. So there's also, that sentencing is right when I'm supposed to be traveling for DCI. So I'm going to need to look at my calendar too. Either way, we will make it work. So sentencing has a date, January 23rd. And we will go from there. I also put out asks for some interviews for after 4th of July. We will see if we get any of those scheduled. Again, my schedule tends to be the difficult one because life is very busy in the summer with the kiddos and with band. Did I not say July? Did I say January? July 23rd. I 100% didn't even clock that I said January. If I said January, I'm sorry. July 23rd. July 23rd. I meant July. The other one, just pick a month that starts with a J. The one we're in. I can't believe it's July today. Honestly, it just can't. Since Monday, I mean, and I got home pretty late on Sunday from driving all over to see band. So it's been kind of this has felt like a whirlwind to me. Let me know how it feels to you, but it has felt like a bit of a whirlwind. So July, we will see sentencing at the end of the month, July 23rd. And then if they need more time, it will go to the 24th. We have other court that is coming up that we will peek in on. There will be more questions to come. I'm sure there will be more statements to come. We can talk about those early next week. It is the holiday weekend. We're coming up on 4th of July. Honestly, I want Team Baker and the mods to have a little bit of a break. The Karen Reed case is a lot of energy and a lot of work. Any trial is, not just Karen Reed specifically. All trials are a lot of energy and a lot of work. I want to make sure everyone can take a little downtime with their families and their friends for the holidays. Today, they're going to be working on case briefs. We will have a podcast out for you Monday. I'm going to be recording that tomorrow. So Law Nerds, I will record that with you tomorrow. But we're going to have some scheduling changes throughout the summer just so that I can travel to go see my kiddo perform in band, because you never know what life brings. And so when you can go see the live music, when you can go see your kiddo who's on the road and I'm all emo about it because I miss him, you do it. So that's what I'm going to be doing. I'm going to be taking all of our internet solutions with us if I travel so I can stream. But I anticipate a lot of the cases that we're covering after the sentencing in this will be a little bit quiet. I anticipate that we will have a little downtime in the summer, and then we will get ramped back up for trials in probably August. So it's just going to be trying to balance all the life things and keeping you in the loop with the cases. And we'll be doing that. So stay in the loop with the Law Nerd app. We had a lovely chat with the app team yesterday. So we are optimistic that we have now broken everything that can be broken and will not run into problems again. We are told again, but I am optimistic. I remain optimistic because we broke things in a different way than anyone thought we could break them. So yay for us. It's fantastic. And we will keep you in the loop in the app. The law nerds break things, and we are trying to fix them so that they don't break again. And we've got a little time to figure that out. So we will be making sure that it won't happen. I will keep you in the loop on what the docket looks like and what cases we'll be covering. So Kate had the last question. Emily, I don't know if you answered this, but how did you not cry in court in murder cases? I wasn't always successful. With it, especially during impact statements. I was better at just letting tears fall and wiping them away. But I wasn't always successful at it. It's hard. The hardest thing for me was reading victim impact statements into the record. That was very hard because they're written in the first person, and it's hard not to feel it. It is incredibly hard when you are taking that emotion on with families. It is easier when I am asking the questions. It's easier to be in like work mode and in game mode, and then let the feelings come later. I also had built up some pretty thick walls, which isn't always a healthy coping mechanism, but we can talk about coping mechanisms another day. But impact statements were gutting and difficult. There were times in witness testimony that it was difficult, and it would be a fight of like, take a breath to not be emotional when people were emotional on the stand, telling you the worst thing that has ever happened to them in their life. It is hard. Impact statements were hard. But also I had some pretty big walls built up around all emotion. So I've worked very hard to undo that. But there is a work mode where you get into work mode. And so you care about the cases that you're working on. You care about the people involved in those cases. You want them to feel heard and supported and feel like they have justice. And you also know that there's nothing you can do to bring back what was lost. There's nothing you can do. The best you can do is have a court or a jury say, this person did this thing to you or to your loved one. That is really the best you can do. And they will be in prison for it. But it doesn't bring anything back, and that is difficult. But I also always tried to set those expectations at the beginning, that I know that there's nothing I can do to undo what was done. I know that there's nothing I can do to really, truly make it right. But we can try to get to the truth of what happened. We can try to show a jury what happened and hope that they come back with a conviction and that that person is not a threat to anyone else ever again. That's what we can try to do. But we can't bring it back. And it's hard because you're dealing with what happens afterwards, and you have to also explain all of the rights of the defendants and explain that these are all the rights they're going to go through. And it's going to feel frustrating because you were just living your life and this thing happened. And now you have to deal with what comes from that. But they have quite a lot of constitutionally protected rights, and you had no choice. And so that is also a difficult thing to help people work through, because it's a hard thing. And it's a hard thing. So that is the reality of it. I didn't always do it well. I always did my best. And I always tried to make sure that families felt heard. Even when they didn't disagree, even when they didn't agree. And there were cases where victim families didn't agree with what I was choosing to do or with what all of my 10,000 bosses were choosing to do. There's times. And I tried to explain why we were doing the thing and why it was the right result. But it didn't always feel like the right result to them. And I understand that. And that's hard too. But the role of a prosecutor is that generally everyone's mad at you all the time. And once you accept that, it gets easier to do your job. You're like, well, most people are going to be mad at me all the time about everything that I do. And we're going to do our best. And that's really all you can do, is the best work that you can do and do it ethically and search for the truth. So, but with all of that, I don't know if everyone's going to feel like the truth has been searched for in this case with this plea, because now it's done. And with the Kohberger case being done, it is probably an unsatisfactory result for some. I don't know how you guys feel about Kohberger saying that he is guilty and he's taking this plea because he is guilty. We will see, but I will link our unlisted video down below so that you can watch the entire hearing if you want to with closed captioning. If that is easier for you, that will be linked down below so that you have that there without any commentary or anything else, without any interruption. There wasn't a lot of interruption today. And we will talk about the docket in the days to come. I hope that you all have a safe and wonderful 4th of July. This case is an emotional one. I absolutely get it. So it's hard. And I understand all of the different aspects of hard. And look, complex emotions are a thing. And so it's okay to be disappointed that you wanted to see this trial go forward and see what the evidence bore out. It's okay to feel relieved for those that don't have to testify and might be able to move on with their lives. It's okay to feel outraged and sad and frustrated for the families that don't feel like this supports them. And it's okay to feel compassionate and relieved for the families that feel like this is a way for them to move forward. There's a lot of emotion in this one, and all of those feelings are okay. What happened today in this plea is well within the rights of the law. It's well within the bounds of the law. I think the court handled it with compassion and integrity. And even though there are some that are going to disagree with this plea, it is within the bounds of the law. There is nothing wrong with this, like legally wrong with this plea deal, even though I think some feel emotionally that this is a wrong outcome. So I hope that that makes sense. Take care, members. I will let you know when we are going live to do our members behind the scenes of the podcast. I will keep you posted on that. It'll be early, probably tomorrow. For all of you that want to hear about other cases, we will talk about them tomorrow. And for all of you that joined me again, making this the #1 place to watch live court and live trials, thank you for being here. Thank you for being a Law Nerd. Take care of yourself. Take care of each other. Have a good and safe 4th of July. And remember, Uber's always an option. And fireworks go boom. Be safe with them. I mean, depending on what state you live in, some places you can't do that. But where I live, fireworks go boom for days and days. Take care of your paw nerds. Be safe. And I appreciate you. Law Nerds, it's time. Mods, thank you for all your work. Team Baker, thank you for all your work. I will see you guys soon. I will keep you up to date on everything in the app. All right, you guys, have a good weekend. It's time. It's time to play the outro. I will see you soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.